Talk to the client and let them know that it's an illegal thing that they're doing, and maybe they'll change their mind.
That's really best practices for any kind of, when you're dealing with, say, a listing, for example, like this here, is to, rather than turn it down flat, is to try and talk them out of their position. And that's where, you know, you're sort of treading a fine line between just sort of annoying them for the sake of trying to set things right, and just saying, I can't work under these conditions, and just getting up and leaving. For me, I think, you know, based upon experience that I've had in the past, that's the route that I would go. I would feel like it was my responsibility to explain to them, I appreciate what you're saying, but, you know, here are the things you can and cannot do. And if you can function under that, under the rules I'm laying, the ground rules I'm laying out, then we can work together. If you can't, I can't help you. And I'm not sure how direct even some CE classes are in that regard, but it's the kind of thing where it's important to think that way, because your whole frame of reference is to make the sale. Your whole frame of reference is to get the business, is to pick up the listing and to go on and sell the property. So you have to counter that by saying, but if it's not the right kind of listing, I just can't. You know, the tendency is to want to balance it and say, I'm sure it'll work out okay.
Is it recording?
Yes.
Okay.
So, yeah, the general theme is you don't want to work and can't really work for anybody who's going to be displaying discriminatory behavior. But that situation, well, as I said, but that situation that comes up where somebody just says, well, we want somebody acceptable to the neighborhood. How do you prove that? You know, if that's all that's ever said, it's hard to say. A lot of what goes on with fair housing is smokescreen kind of behavior, where people will say certain things and sort of belies their position without clearly in a provable way pointing out that they're discriminating. So it won't always be clear, especially, I mean, in my experience, being a white male broker, I think that's, and older, that's, you know, more likely people might make the assumption that I would be willing to go along with a wink and a nod of discriminating against this group or that group. You know, if you're an obvious minority person, male or female, I seriously doubt that, you know, somebody, unless they're of the same minority group that you are, is going to make the assumption that it's okay with you to discriminate against minorities. So it kind of depends upon how that stuff unfolds. But I'd talk to the client. Sometimes people will back off. Oh, I didn't mean it like that, or whatever. It's, you know, you have to develop these scripts, some of which are scripts about selling, and some of which are scripts about agency, and some of which are scripts about things like this. It takes a while. So, this very first question, right, is just, you know, should he have accepted the listing? I mean, I think, Kate, you're saying no, right? I mean, just.
Well, the reason why I said no is because after he, you know, as you read down, he talks to Harriet, the manager or whatever, and she says, oh no, I don't write corners. I'm not supposed to do that. That it sounds like, you know, she'd be there and she could be an issue.
Yeah, they write these kind of convoluted, complex problems for us to look at, but clearly that should be bothersome. That really should chafe immediately. And that's the challenge here, especially if you're not used to being victimized by this. It's just like, you know, there's a whole lot of discussion, you know, about sort of white privilege. That's like a common buzzword kind of thing to talk about today. But the issue is that for somebody like myself, particularly for white males, the odds are much less likely that we're going to face any kind of obvious overt discriminatory action, that we're going to know it for what it is and recognize it and identify with it. And if that's the case, then they're much less likely to sort of police what goes on around us, because you just don't notice it. Maybe every woman at some point in time has that kind of sense, and certainly probably most minorities have that kind of sense at some point in time, if you're being talked down to or thought of as being less or unequal or something. So if you've had the experience, I think you're much more quick to recognize it and react to it and put a stop to it. It's somebody like me who's blissfully ignorant and doesn't even realize that somebody's saying to me, I don't want any minorities, or when we leave the neighbor's want other people like them to live here or whatever. If somebody said that to me, I would go, oh, they want more golfers, or oh, they want more whatever, you know. I wouldn't even think of it along the lines, you know, as being a fair housing thing. And that's where you have to kind of train yourself to recognize those things. Because the risk is you're on the wrong side of that finger-pointing exercise in court or at a disciplinary hearing. And you may not even ever have intended it, but yet there you are. So yeah, I think there's a lot of things to talk through, right? Should he have accepted the listing? He's saying, I'm not discriminating the owners or the guilty party. I don't know how you prove that. When you're the professional, how do you distance yourself from your client's behavior if you don't do it right up front? It's not like a disclosure thing where, you know, they don't want to disclose that there's a basement leak, so you just disclose it. You know, well, my clients don't want to tell you that they're prejudiced, so I'm going to tell you that they are. How do you do that? You know, and I just don't think you can. I don't think it's the kind of thing where you can do that. So you really need to deal with it up front. So whether he should have taken this specific listing or whether it's such a mess that he just shouldn't have, you know, because it isn't just the sellers, you've got their other agent, it's kind of messy. Can George filter potential buyers by credit score?
Yes.
Yeah, it should be pretty clear. And then by race? No, right, and that should be obvious. So you can also discriminate on other financing bases. What's another way in which a seller might want you to discriminate against buyers in a legal format besides credit score? It's fairly common in upper end single-family price ranges or with certain kinds of investment property that sellers will ask you to discriminate based upon who's already pre-approved or who can demonstrate that they have the funds. So that's a common thing. And it's discrimination, but it's discrimination on dollars, not on any protected class. So once you get up into a certain price range, some people, they just don't want their house, which, you know, they don't want it to become like a tour museum for the neighborhood or for people in town or whatever. So, you know, all buyers have to be pre-qualified. With investment property, it's not at all uncommon. You can't even get the listing packages, talking about property outside the MLS, you can't even get listing packages unless you sign a confidentiality agreement and provide some information about yourself as an investor or entity or whatever. Go ahead.
When you're going to show buyers,
Yes.
don't you pre-approve them first before you?
You should, but most, I shouldn't say most, many agents do not. And in the case of sellers discriminating on that basis, sellers can insist on proof. Send us the pre-approval letter before you even show the property. That's a little bit different than just taking the word of an agent or making the assumption that the agent has done their due diligence with their buyer.
So what do you do in a case when you're sitting in the office and somebody walks in and says, hey, I saw a sign in the front yard on 8th Street. Can somebody show me the house?
That's a personal business decision for you to make. And a lot of times agents will just jump and go. And that's certainly a reasonable business temptation because the risk is that if you ask somebody to jump through hoops, they might not want to jump and they might go somewhere else. Mm-hmm. That's a very real challenge to face up to. The theory is that you would sit them down, get them a cup of coffee or a bottle of water, and you would talk about, you know, pre-approval and pre-qualification and how do they know that they can even afford the property and that kind of thing. If they've worked with anybody in the past, and you would talk with them for 30 to 60 minutes. You disclose yourself as the designated agent of your broker. You might ask them, am I just going to show you this house, or am I going to work for you more? You might even take the opportunity to sell them on an exclusive agency arrangement. But probably in most cases, somebody's like, yeah, I get off floor time in 15 minutes, you know, or I'm tied up for 4 hours, but how about if I refer you to somebody who's in here? So those are just business decisions you need to make. You know, the theory in these kinds of cases is a lot easier than the reality. My experience is that if you don't pre-qualify people and if you don't vet them and their interest level and how serious they are, what you'll end up doing is just taking them on a tour for 45 minutes and you'll probably never see them again. Or worse yet, you'll show them that place and you'll send them emails for 4 weeks with all kinds of data only to have them buy one of those properties from somebody else anyway, because they're getting that from 5 different agents around town. I worked with a guy for, I think, 6 months on $20 million apartment buildings. only to have them buy one through another broker. And I said, why didn't you tell me you were working with somebody else? So I was working with a bunch of people. I said, we had this conversation and you told me that I was, well, you were at the time. You know, so I mean, that's the problem. Everybody has access to the same data. You know, sometimes people can't find, like inventory is light right now. So some buyers can't find the house they're looking for. So you send them listings, or you can set the MLS up to where it sends them stuff every day, even twice a day, or whatever's new or has changed in that particular set of criteria that you've set up in the MLS. But maybe what they want isn't there. So they get tired of waiting to get it from you. So they go to somebody else who sends them the exact same stuff. And now you've got two agents sending them the exact same data. And a month goes by and they still haven't found it because it just isn't in the market. And then some other third agent gets involved. And so many people are doing the same thing because people don't ask. Or they don't get the buyers to commit. And we have to remember that the consumers don't really know how our market works. And it's up to us to kind of set some boundaries and rules. Like I said, that's easier said than done, of course, because when you leave here, you're going to be trying to figure out how do I make money. And it's hard to make money if you're watching a revolving door of potential buyers leave because you'll only work with them if they sign an agreement or whatever. And I don't know that happens, but that's something you'll have to figure out. I just know I spent a lot more time chasing people who went nowhere than I ever did, the other way around. So any other comments on George and whether he's crazy to take this listing or should have taken the listing, or think you can talk your way through all of this with sellers and another agent who have problems? The property management, that's what Harriet is, right? She's the property manager. I think it's a mess. I'd try and figure out my way through it, but this might be one to walk away from. Just my personal opinion. It's just a case study, but sometimes, as they say, discretion is the better part of valor. Question number 2, now that George has accepted the listing, could he be guilty of fair housing violations by association? As far as I know, there was nothing, by the way, in the statute called guilt by association, so this is just specifically a common law interpretation here of how do you think a court would rule, or a hearing agency, or HUD, for example. What do you think of this idea about guilty by association?
Wouldn't you have to actually injure a party for this to even go any further forward?
Anyone who's damaged under the Federal Fair Housing Act has the right to bring suit, has the right to bring forth a claim. So what that means exactly is pretty wide open. Courts tend to interpret these statutes pretty broadly. They tend to consider almost anybody who's damaged, as being acceptable, including fair housing testers. So all it would take is somebody who's, comes along who's a tester, and you could be subject to a negotiated settlement. So the answer is yes, somebody has to have damages, but those damages don't have to amount to much, and they add up pretty quickly. I mean, I know for a fact there are all kinds of people who just have discriminated. I was stunned at some of the things that my colleagues, some of my very successful colleagues, even would say from time to time. I grew up in Naperville. I grew up in a family that probably was there because we didn't want to live any closer to Chicago. But I never heard my parents. My mother was a very open-minded person. I think my father was relatively prejudiced, but I never heard him say a word at home. Never. So I didn't pick up any of that. And so I feel kind of fortunate because I don't have this sort of pall of what the conditions were like in the 60s that I have to sort of cast off. Even with all that said, I still find myself from time to time thinking in terms, I think, oh, that's not right. Why do I think that way? And catching myself. So I think you have to look at this kind of thing and say, sort of, where do I want to be? How do I want to handle this? And I just know it's much better today to come out and be very quick and say, this is just, you can't be doing this. And I think NAR produced a video a few years ago to that effect, and that's going to be the training you're going to tend to get. CE classes are a little bit like this, nonsensical case studies that you don't necessarily really connect with unless you've been victimized, but real practice is a little dicier. This case is maybe a little bit over the top, but it is the kind of thing you have to seriously look at. You just, it'll just happen one day and you won't understand how it happened. So I guess the answer to this possibly is yes. Could he be innocent because he is only following orders?
No.
Yeah, I think that's pretty unlikely. The answer key the publisher has says, convicts often use the excuse, I was only following orders, with varying degrees of success. There's something to be said for loyalty, but yeah, this is probably not one of those places where you want to hold that out as your best excuse. Again, we're professionals, we should know better. And if you suspect, just go back and talk to your broker. Here's the circumstance, do you really want to do this? Keeping in mind, you could sign a listing agreement and not actually have bound the brokerage firm, because the broker's got to countersign it. So if you're embarrassed, or if it's a little bit of a problem or something or whatever, or you don't think you explained it well, or you think maybe they've agreed, but you're not 100% sure, or you do it and then you're seized with fear after you leave, before you sit down with your broker to have them countersign that listing agreement, explain to him or her the whole situation, and maybe they'll decide, oh, let's pull the plug, we don't need a case like that, we don't need the listing that badly. Because ultimately it is their decision as well as to whether they should, your decision to whether you want to represent the broker in that matter, but their decision as a broker whether they want to take it at all.
It sounds to me though, in some of these case studies, that a lot of people not involve their brokers?
Yes, it's very common to not involve your broker, because the broker in a simple deal is an afterthought, a necessary evil. I mean, if you go and list a simple listing without any case study type problems, your broker just gives it a quick 30-second look over, signs the contract, copies go in files, and that's it. Because there isn't anything for them to consider. You stay within your employment agreement in terms of the commission rate, with the property type that you're selling, with your level of expertise or whomever you're partnering or mentoring with. That part's simple. You're going to take everything else is pretty routine, putting it in the MLS. All that stuff is pretty much in your hands. So unless the broker has some basis for suspicion, or there's some red flag that's raised on a business basis, similar to what I already might have mentioned, the broker's not going to think very much about that at all. And if agents are listing a couple dozen properties a year, of the ones that actually sell, and maybe a few more that don't close, and you've got an office of 50 agents, that's a lot of stuff to sign off on a monthly and regular basis. Because besides just taking the listings, you've got buyer agency deals, you've got contracts to deal with, closings, distribution of money, training to arrange. So and some office brokers are listing and selling themselves. Now, maybe not a lot, but some of them are. So they're busy people. So yeah, they're not going to put any more time, effort, and energy into looking that over. It's a standard contract form. What is there to see unless you tell them?
I'm just thinking, some of these, you would think that you as a broker, knowing that they represent you, they've got their license on the line.
That's true.
Everything you're doing, so.
And maybe that's why we see, regular disciplines where brokers are getting dinged alongside their sponsored licensee, because it's something that they could have avoided with additional supervision. It's a strange anomaly in Illinois, right, where there is no limit on how many offices you can manage. Yet it's not an acceptable excuse for a broker to go in front of IDFPR and say, well, I didn't know what Georgie was doing because I got 3 other offices to manage and I can't follow everybody around. Yet that's what some managing brokers will say. I can't keep up with my office in Aurora and Sugar Grove and Elburn and Yorkville, So, the state doesn't really care numerically, but they do care qualitatively. And so that's a business decision for managing and sponsoring brokers to pay close attention to. I think there are certain critical sizes to brokerages where you can, if they get to be too big, you really got to have full-time supervising managers who don't list and sell. And if you're really little, it's okay because you can fit that in. But there's somewhere in between where it can be a little bit awkward. Because you're still trying to make a living. There's more money in listing and selling than there is in managing. So people who manage offices tend to be part-time managers and full-time brokers, listing and selling with their clients. They take the management because they make an extra 20 grand a year or whatever to keep track of it. But they're just out competing with at least the offices out here that do residential. But they're doing that because it gives them a way to compete with, or make a little extra money while they're competing with the other agents in their office that they're responsible for supervising. Bigger offices will have full-time managing brokers, who don't make a lot of money, but they're doing that because they just don't want to list and sell much anymore. Or if they do a couple deals a year and that's it, friends, kind of like I do while working here. But you're right, talking to the broker is an important thing. Question number 3, is Harriet guilty of fair housing violations?
Yes.
Yeah, what's she basically doing? I mean, she's basically screening people or whatever based upon protected class status, right? I mean, oh, you're one of those, we don't want you here, or we're gonna treat you differently or something. So, the follow-on question is probably more compelling. What fair housing what's she violating here? What's she actually doing? Anybody remember from reading this and doing this over the weekend?
Well, it's kind of a human rights discrimination, right, of race?
Yeah. I'm just trying to find specific examples. So she's the property manager, and yeah, the business have given her explicit instructions not to show apartments to foreigners. So national origin, race, ethnicity, color, whatever, however that might play out. Could be religion, I suppose, depending. Certainly would be, common today, people to say, I don't want to rent to or sell to or whatever, to Muslims. Then she says, well, it's not as bad as it sounds. Everyone knows foreigners don't work as hard and don't make as much money. They wouldn't qualify for one of our apartments anyway. Awesome. What a great screening process. So yeah, so I mean, and I guess she's just declining or refusing, so it's not a case of necessarily identifiable thing of steering or redlining or something like that. She's just saying no, and refusal is, grounds for suit or for damages. Is George obligated to report Harriet to, in this case, IDFPR? What do you think? If you're in George's position and you come into this and you decide you want to look into it further or try and salvage it or whatever, and you go and talk to the property manager and she's clearly violating, a licensed property manager, she's clearly violating statutes as you understand them, what are you going to do about that at that point in time?
Well, doesn't it have to be the person that's being discriminated against that files? I mean, it's hearsay until somebody actually says, hey, this woman turned me away because I'm Muslim.
I don't think it's hearsay as long as if she tells you, if she comes right out and says, we discriminate against people based upon their national origin, which she has in this case, right? It's only hearsay if somebody who wasn't victimized and who isn't involved tells you, then that's hearsay.
Her word against his, though. I mean, he hasn't been discriminated against.
Right, but she's admitting it. So if she admits it to you, you're just gonna say, well, I can't trust that she's telling me. She might be lying about violating the law, so I'm not gonna turn her in.
I couldn't find any requirements anywhere that said you have to turn somebody in.
I couldn't
And, HUD only says that the aggrieved person files the charges, and then if they're found guilty there, then the disciplinary board takes action.
Right. Yeah, there is no requirement to turn in a colleague or, a fellow licensee. I think you go back to your office and talk to your broker about that too and say, hey, while you're thinking about this whole thing, I gotta tell you that the current property manager has told me that they're discriminating based on this and that, and they're also not following, lead paint rules and whatever. And maybe the broker maybe the thing is so messy, the broker just says, no, just don't do this deal at all. So for me, and I've said this to you guys I think before, my preferred methodology is to talk on a peer-to-peer level. So if I'm a sponsored licensee and Harriet's a sponsored licensee, or even she's running her own shop, I would talk to her directly and say, Harriet, I don't think you should be doing that. Those sound like fair housing violations to me. And this thing with you not giving out the lead paint thing, that's, that's another problem. Then if that goes nowhere, I would talk to my broker and let my broker decide if he or she is going to talk to to Harriet or Harriet's broker. So my opinion is, you know, if you find an agent who's violating fair housing, you should approach that agent, or if you should forget it, one or the other. Otherwise, go to your broker and let your broker decide to talk, not to that other agent, but to that agent's broker. Maybe they know each other, and at that kind of level. There is nothing wrong, there's nothing illegal or unethical about turning in one of your compatriots. I mean, if you're convinced that what they've done, you can file a complaint with IDFPR. Or you could go to your local board if they belong to the same local realtor board that you do. Where that would go, I have no idea. You can always call IDFPR anonymously and say, hey, I'm a licensee, and I ran into another licensee who told me they're doing this, and I'm a little uncomfortable about that, but I'm not sure I want to get in the middle of something since I didn't witness anything firsthand, and I'm wondering what the proper course of action is. And they may just tell you, well, contact HUD or contact the Illinois Department of Human Rights. I don't know how anonymous HUD or DHR might be. IDFPR, I've called a number of times, and they've never once asked me, who is this, what's your license number, what's your social security number? Never. They'll tell you, who that you should talk to, or whether it's a sanctionable offense or something worth pursuing. They'll even offer you to transfer you, whatever. But I've never had them say, name, rank, serial number, and then we'll go from there. Which makes it a friendly place to sort of call and ask about things. If your broker has problems, they can probably, if they're realtor members, they can call the Illinois Association of Realtors legal hotline. You don't get a legal opinion, but you get the opinion of a lawyer who knows the license law, who knows fair housing. It's a way to talk through some of these things. So is George obligated to report Harriet? No. Should he? Somebody there probably should turn her in, but who exactly, not sure. Another thing you could do is suggest to a fair housing agency that they go investigate the place. Don't take the listing. Go into a fair housing agency. Farthest one out here, I think, is in Wheaton. As I mentioned, John Marshall Law School, where I earned a master's, has a fair housing clinic there. There are about a half a dozen or so in the city and around the suburbs that will do testing. And so that would be one way to deal with this, and then let them take it from there. Same thing with HUD. Handle it how you think is appropriate. George is employed by Millennium Realty. His sponsoring broker, Ted, has not been informed of the circumstances behind George's listing. Way to go, George. What is the extent of Ted's liability if the state and HUD rule that George is guilty of discrimination and license law violations? What do you think? George just buries his head in the sand and says, I'll take the listing. Either Harriet's my hero, or I hope that nothing bad happens while I got the listing. Maybe nobody will blame me. And then goes forward. What's Ted's liability when George gets hung out to dry? Does he get hung out with him? Can he say, I didn't know? What do you think?
I think he's responsible.
Okay. How about some of you who are quieter? Same? That was a very eloquent response. One syllable even. Anybody else?
I don't think he is. George didn't tell him. I mean, does your sponsoring broker have to like dig deep into every house you're selling? I mean, if you don't tell him, how will he know?
That's a good question. I don't know. But that certainly, goes back and begs the question that Georgie was asking earlier, is that, how much time are brokers putting into it, and shouldn't the broker maybe be spending more time supervising and less time networking, or less time listening and selling, or less time, playing golf or whatever that people might do. It's an unfortunate thing, and I don't want to think that Ted should be responsible either. But I think there's a really good chance in a case like discrimination that he is going to be. May come down to policy and procedures. How long since you had training on this in the office? Did your policy and procedures manual, does it say, does it address this kind of thing? The more proactive steps you can show as a broker that you took to avoid this, the greater the odds are that you'll be able to avoid sanction at the time when it counts. where you can hang George out as a rogue who is atypical and, you know, that kind of thing. But if there's any history of this happening on a repeat basis, if there's any history of you being lax in your supervision as a broker on any issue, not even fair housing, but anything else, then I think, you know, you've got a problem that you're not gonna get around. So I don't think we can definitively say that, yes, Ted is definitely liable, but we can say there's a really good chance that he's gonna end up being liable, however unfair that might seem. I want to think, Tom, exactly like you do. I think that makes a lot of sense logically. What I believe happens is that in certain areas, regulatory agencies and courts have less tolerance. And I think when it comes to civil rights, there is less tolerance for egregious behavior or the supervision thereof than there might be if it was something else. Bounce the check, oh, we're not gonna hold the broker responsible. Discriminating against people, working with another broker willingly who you know is discriminating against people, they're probably gonna go after everybody. It just seems like that's a statement needing to be made. And the more, personal opinion here, that the more Fergusons, Baltimores, et cetera, that are widely spread on the media, the more sympathetic people are gonna say, that's just enough of this, we gotta deal with this. And anybody who then gets caught up in that is gonna be more harshly dealt with. Completely off the topic of civil rights, but like the teachers in Atlanta, the 11 teachers who are going to prison for God knows how long because they gave into a system where they helped kids, you know, get over national testing. Rather than deal with the fact that whether we should have national testing, we just send people to prison. That's the problem I think you have with civil rights in part, is if you're caught up in it at all, there's probably no escaping some kind of attachment to it. So I think Ted's gonna be held liable. Those are the odds, I think. To what extent might professional liability insurance provide coverage for George? What do we call professional liability in our business? E&O, right, errors and omissions. So what do you think errors and omissions insurance will do for George as a sponsored licensee?
I don't think it pays for crime, does it?
No, and this isn't necessarily a crime, it's still a civil offense, but it's still gonna be considered an intentional act. And so it won't be covered. So what about for Ted? Not his intentional act. You think the managing broker or sponsoring broker is gonna have any coverage?
He has a better chance at it than Ted or than George does.
I think the first thing the insurance company's gonna try and do in any kind of case where you're violating the license law, violating fair housing law, civil rights acts, anything related to that, the very first thing your E&O carrier is gonna try and do is get out from underneath liability. They're gonna try and get out from underneath the obligation to fund the litigation. They're gonna go to court and say, Your Honor, this is outside the policy, and then you're gonna be hanging there by yourself. So my guess is that whatever argument would apply to the license law and fair housing is gonna apply even more so with a private insurance carrier, and they're gonna get out from underneath this entirely. And so it's gonna all be on George and probably on Ted and the brokerage firm. Number 5, if George tells Ted about the Bivens and Harriet, does this change his overall liability? Based upon what we said, this should be pretty straightforward, right? We were a little bit on the fence, now we know for sure he's cooked. He now has no excuse. So if he knew, it's, you know, did you know or should have known? And previously we were basically saying he should have known. Now we're saying he does know. He doesn't have an excuse left. So if 5 is accurate, then Ted knows, then he's got no excuses. Number 6, what action should Ted take to limit his liability? And part of it's in that next question. Should he have a written policy and procedures manual in the office? We know that's an absolute requirement in Illinois, right? Has to have one. And what should the manual say about issues similar to the one that's facing George?
Do they have meetings?
Meetings?
Yeah.
Yes. So real estate brokerage firms will have weekly or bi-weekly, worst case monthly, but usually they're every week, sales meetings. The problem with the independent contractor model is that your sponsored licensees don't have to show up because you don't control what they do. So sales meetings are blown off by a lot of agents. A number of brokerages today, I think Redfin is one, and I'm trying to think of a couple of other that are newer firms, are trending towards the employee model. Not necessarily for better compensation for agents or benefits or other things, but just so that they have greater control. And then if they set a meeting, it's grounds for termination if you don't show up. But that allows you to have greater control. It also gives you greater liability. You now can't say you don't know what your people are doing when you're seeing them on a consistent basis every Tuesday morning between 9 and 11. So these regular meetings can do a number of things. They can give you the opportunity to do training for things like this, but they can also give you the opportunity to do sales training and tours of new listings. So if an office, for example, let's just say it's Aurora, as Aurora is pretty large, say an office concentrates on the Aurora market and there's 30 agents in that office, you might have, every week you might have 5 or 6 new listings. And so they're going to be open for just that office during that period of time. The listing agent would tell the clients, our office is going to come through sometime between 9 and 11 on Tuesday morning. Be gone from the house, whatever, and I get the keys, or we'll use the lockbox to get in. And you want all 30 agents to come through, of course. Sometimes it'll be 8, 10, 12, 6, depends upon the week, depends upon who felt like it, depends upon who looked at that and went, oh, this is of interest. I sell in that kind of price range. I want to see what it looks like. So the meetings can serve a lot of purposes. So let's say they do revolve a lot around tours and sales presentations and self-improvement seminars, but nothing regarding your policy and procedures manual or fair housing. They might not do you any good for liability avoidance anyway.
I'm just trying to figure out how, I don't think I really ever want to be a managing broker, but if I was, there's got to be some way that you can get this, like maybe when you first, I'm trying to think, like when you first bring someone in, could you have a mandatory so many sessions with them that they have to be there for this so that they learn these policies and procedures and then sign off on it or something like that?
That's common for medium to large size brokerages to have training. Not to mention franchise names for any particular reason, but Coldwell Banker, for example, has a program they call Fast Start. The Ketleys, who have or independent office here, Ed Senior was a former teacher. I think his wife might have been as well. They designed all their own training. How much of that training, for example, that they have is specific to license law related issues, and how much of it is like, here's what you do as an agent to make a living. Here's how you farm a subdivision. I have no idea. I couldn't say. But some brokerages are just better at offering training to their agents. So I think quite a few brokerages. I remember a number of years ago, a woman who runs a different firm now was a RE/MAX managing broker. And she called me and she goes, what do you think of the idea of all the RE/MAX offices setting up their own training? Because each individual office was kind of left to do training. And she was saying most of our agents are already experienced, but it would be nice if there was like every RE/MAX brokerage in the northeastern Illinois, for example, could send their agents to a particular place where the offices would pay for the trainers or whatever. So I thought it was a clever idea. I don't think it ever materialized, but it kind of depends upon a lot of different things. So like I say, Coldwell Banker as a franchisor made that Fast Start training available to all Coldwell Banker agents. So you go to Des Plaines or Algonquin or wherever they held it, and that was a requirement. I don't remember if we had to sign off on things, but attendance was taken, and we dealt with basic issues of agency and contract law. A lot of the things that we're touching on just a little bit here in this course, but still in greater detail, and in conjunction with what the company's policies and procedures were. So you might want to look for that when you're trying to figure out where to hang your license. Who's going to train me? You should be prepared to ask the brokers, very simply, who's going to teach me all the things that I don't know, which there are a lot. You've basically been exposed to them, but how do I actually turn these tools into money-making opportunities without violating laws and doing ignorant things unintentionally? Some smaller firms will have more of a mentoring program where it's a one-on-one. You come to an office and you and I hang around, for 3 weeks, or whenever you have problems, you come see me if the broker's not available. And in those mentoring kind of programs, the mentoring agent maybe gets a very small piece, not of your share of the commission, but of the brokerage's share of the early commission, of the first commissions, whatever. It kind of depends upon how they're set up. So again, ask about that when you go places, if you aren't already figure out where you're gonna go. Let's see. So, yeah, so we know there needs to be a policy and procedures manual. It should be trained on. That kind of training there, MLS-related training, including contract and stuff, is also available to members of the local realtor boards and things. So that kind of training should be taken advantage of even outside. You can spend a lot of time training. You don't want to train to death. You've got to get out and list and sell, but at the same time, there's a lot to learn. And you shouldn't be terrified by this. You know, people don't go around committing fair housing violations every day. Most of it's common sense, I think, but you should be okay. But, you know, keep an eye out and double check this stuff. So the last question was, what should the manual say about issues similar to the ones facing George? Whatever the office policy is, the fair housing, and it may seem redundant, but you want to repeat what's in the law. You don't want to leave anything to chance. It's kind of a crazy thing, but I learned this in leasing a long time ago. It made no sense to me until I really thought about it for 30 seconds. So for example, in a residential lease, you have to make it a clear violation of the lease if somebody violates the law. So somebody in your residential building commits a criminal offense, criminal act on the property, like they're selling drugs, for example. You want to have that in the lease, that you have the right to evict them because of that. Why do you even need to have that in the lease? What's the point of that? Well, your lease is it's a civil law kind of statutory common law, or excuse me, state common law agreement. You're not the police. You have no right to evict somebody for a criminal act. That's for the police to do, unless your contract gives you the right. Contract law and criminal law are two different things. So there's a little bit to be said for redundancy in some of these areas, and the policy and procedures manual is one of them. If you want to hang your hat on policy and procedures manual and the training that goes along with it, start with the law and whatever the law is and whatever industry ethics are on top of that, and then either have that be your base or make it worse, you know, harder on your agents, and then you can show, yeah, we've done everything. If you just go to a hearing with IDFPR or HUD and say, well, everybody who's in the business knows you can't discriminate on the following 7 classes, that is not going to be much of a defense. So that policy and procedure manual should very clearly spell out even the things that should be obvious to students who've graduated or people who graduated from the class and taken the state exam and maybe practiced for a few years. And then, of course, we talked about have sign off on it, maybe have them initial every section. You know, so when somebody goes through, they'll initial the fair housing section, they will initial whatever. Number 7, did George or Harriet violate confidentiality when they discussed the Bivens situation, right? So the Bivens are the sellers, or the owners. Should either George or Harriet have obtained permission from the Bivens beforehand? I mean, theoretically here, right, George has an agency agreement, Harriet has an agency agreement, right? Both of them are under specific, limited sort of, Harriet's a general agency regarding leasing and property management, and George, through this broker Ted, had this listing agreement, presumably exclusive right to sell. So they each have agency agreements. Can they talk to each other about the mutual client? What do you think? Got a couple of sures, head nods.
Legal activity would be protected.
So are you saying that there are cases where maybe you can and cases where maybe you can't? And this is a case where you can? Was that what you were saying, or?
Yeah, I think so. It's definitely a case where you could reverse.
So if you're going to them and saying, I think the owners want me to discriminate, do they want you to discriminate too? That kind of thing? I mean, is that what you're saying, or?
Well, I think that her talking about the illegal activities wouldn't be.
Yeah, she just kind of blurted that out from what we can tell, right? I'm not sure who's violated what here, but anything that she has revealed that is quoted here probably shouldn't have been. I mean, I think the answer generally would be no, that you shouldn't be talking to each other about your individual agreements. You each have limited scope of agency based on that, and George should be talking to Ted or to the Bivens, and Harriet should be talking to the Bivens and or her broker, unless it's some extraordinary circumstance. Like, you know, does your client actually pay you? You know, we're signing this agency agreement, we wanna make sure we're gonna get paid. Do you get paid? That's more of a credit check kind of thing. But yeah, I don't know, I did look at the quote, go back and look at the quotes to see if George has violated anything here, but Harriet, I think when she's kind of talking off the cuff, probably should not be. Not because she's giving up, hey, my clients are violating fair housing law and I'm helping them. Not for that reason, just because anything that is not relevant to her mission, to her clients, probably shouldn't be disclosed, unless, of course, she has that in writing. If Bivens had given her written consent, that yeah, they send her an email, cooperate with George, tell him whatever he needs, give him all the information, help him out, then you're good to go. But I don't think we know that that happened here. Any other comments or thoughts or whatever about this particular case? All right, I think up online in the course shell, if you had the chance to look at them at all, or took the initiative, there are two agreements that are up there, and not something you necessarily need to read, but that I thought would be worth seeing. I don't know if I have the right copies here or not. Probably should have brought that up online. One of them is the more interesting of the two. I think one of them is between HUD and the Housing Authority of Baltimore, City of Baltimore, which talks about the fact that, you know, the city itself is violating somebody's fair housing rights, or violating the Fair Housing Act. So, under specific provisions on page 3 of this thing, relief for complaint within 10 days of signing of this agreement, and this is what's known as a consent agreement, Housing Authority of Baltimore City will provide to whomever the complainant was here a payment in the amount of $150,000 via wire transfer, plus legal fees of 10 grand. And then there's a lot of other information here about, you know, training, etc. That's no small bit of damages, $150,000, and that's just a consent agreement. HUD has a lot of weight when it comes to housing authorities because they fund them. You know, federal housing money goes to these agencies. It's just, you know, it's a funny sort of dynamic. See if I can find here really quick. It was a failure to address her reasonable accommodation for transfer or moving apartment, so it must have been a disability kind of case. I haven't looked at it for a couple of years. Yeah, discrimination based on handicap. So just a failure to accommodate somebody in a timely manner. So, you know, again, the number one area for complaints today is disability, and that's the case. Another one that I have up online that I don't have here is against Kent State University Housing Department. You would think college dormitory wouldn't necessarily fall into this category, yet it does. And there the problem was failure to make accommodations for somebody suffering from panic disorder, you know, panic and anxiety attacks. This is not a well-known thing, but it's considered to be clinical. I mean, it's considered a challenge for some people, you know. They have all kinds of, you know, problems, let's say with dizziness or the ability to function. They just can't handle, they, you know, skip automatically into a kind of a fight or flight kind of mode, feel threatened. And so not properly accommodated, it puts them in a situation where they really can't function. And clearly, you know, a probably partially student-operated, you know, with student aid workers or whatever, run housing department wasn't at all prepared to deal with somebody that had that kind of circumstance, and then it led to a fair housing claim, which is unfortunate, but that's the way that it is. So again, depending upon,
I'm sorry, is that labeled as a disability?
yeah, if it's considered an impairment, what can happen is that you might even end up in court to try and figure out whether it is or whether it isn't, and then you're left to a judge making that determination. HUD will only take the case if they believe they can win it. And like every regulatory agency that's overburdened, HUD will press first the cases they think they have the greatest chance of winning. So a case like that wouldn't have gone forward unless HUD was certain they could win, and then there is now up online, either those are the charges or a consent agreement, I don't remember which. This one for Baltimore is a consent agreement. Maybe the one that's up for Kent State is only the charges that are laid out. Maybe it's not a consent agreement yet. Yeah, I think it is. So it gives you different stages of where you can see
So
how.
do the schools have to accommodate for that now?
If HUD's correct, then yes.
Oh.
So as we're getting into more and more sort of scientific discovery and sort of physiological understanding of what different disabilities and challenges are that people face, we've got a wider and wider range as real estate professionals of things to better understand. So the best course of action when something like this comes up isn't to go, I've never heard of that, that's ridiculous, just go away, you know, that's not the right response. The response is, oh, really, I'm sorry, please pardon my ears, I'm not aware of that. Can you point me somewhere where I can learn more about it? In the meantime, I'll check with my manager or legal counsel or whatever and see what we need to do to try and accommodate you. You know, you don't want to be duped, obviously. You don't want to be taken advantage of. You don't want people to sort of fabricate something, but some of these things are difficult to prove. You have the right, the ability to ask for documentation, but it's pretty limited even there. So asking once has been deemed to be reasonable. But then digging deeper, you know, so if you get a doctor's note or letter or something, whatever, that says they're suffering from an impairment or disability, you're taking a big risk. You might win. You're taking a big risk to challenge that, or to dig deeper and say, oh, I don't see that on the list in the ADA or whatever you're going to want to look at. Because if it turns out that they're right and you're wrong, that you're going to lose that argument every time, because the court's going to say, no, that was heavy-handed. You missed your chance to make the reasonable accommodation when it was timely. Not easy, right? I mean, these are complicated things.
So what happens in a case where there's a service animal in a building and you have another tenant that has an irrational fear of dogs?
Yeah.
Can they break their lease and move out?
I think the answer might be yes. You might have to, as a reasonable accommodation to them, you might have to allow them to do that. Now, reasonableness sounds reasonable until you actually try and test it under every possible circumstance. And so I like to draw I can do this for you kind of briefly. The way I see certain kinds of decision-making processes in business, in life in general, it's that very few things are really black and white or right or wrong or on or off. Instead, you have this realm in here that's under the law would be considered reasonable. If you were talking with, say, philosophers or spiritualists, they might say, well, this is the realm of moderation, where sort of moderation in all things fits in here. And everything outside of this circle is extreme. So extreme can be too high, you charge too much for an apartment, you'll never rent it. Extreme can be too low, your rents are so low, you have 100% occupancy all the time, you're not maximizing your income. You can be too far to the left, you can be too far to the right, it's just like being too hot, too cold, and in the middle here is just right. So this reasonableness idea, somewhere inside this circle or square or rectangle are decisions that are reasonable. And if you continue to sort of press them, they go outside here and become extreme. So when you're looking at that kind of situation, when you have one person who has a life impairment, you're anywhere inside here. Now you have a second person who needs to be accommodated. How do you deal with both of them? You have to find some answer to that that's somewhere inside of here. If you can't, then you kind of have an untenable situation. But if you're going to court to defend yourself, you need to be able to show you've exhausted a lot of possibilities. It's one of those Monday morning quarterbacking things. Somebody else is sitting in court taking a pot shot at your potentially pathetic looking attempt to resolve a problem that to other people is very real, and to you is just one more task at work, annoying task at work maybe to get rid of. I don't know. I'm not familiar with a lot with residential management on that kind of basis, so I don't have any experiences in that regard. I don't even know of any good cases to, point you to that says, so-and-so had a cat for a service animal. Cats could tend to be, something that people are relatively allergic to. Reasonable accommodation to a dog, for example, may not mean that you get to select a pit bull if pit bulls are, problematic for your neighbor. I don't know. I just don't know the answer to that. It's a perfectly good question. It's a right on target question. So if you were managing a property, for example, you might want to proactively seek out an answer to that kind of thing long before it ever happened. Any other questions or thoughts about any of these kinds of things at all? I have another case here. I guess I don't think I put this up online at all. This is HUD orders a West Virginia landlord, this is from 3 years ago, to pay $34,000 for discriminating against a man with autism and his sister. So she was caring for her brother who had autism. He was an adult, and they were denied, either renting an apartment, but the landlord demanded that before he would sign a lease agreement, the woman must purchase $1 million insurance policy to cover any damages or injuries caused by her brother, and sign an agreement assuming all legal liability for her brother's actions. In addition, the landlord required the woman to obtain a doctor's note regarding her brother's condition. So she doesn't have autism, right? She doesn't have a disability, but she earns her share of the money because she's damaged. That's the same thing that happens with fair housing testing companies, with lawyers, with whomever, anybody's involved, everybody's going to get paid. So it becomes an expensive kind of thing. So actually the bigger chunk of the money went to her. And she was caring for him. I don't think very little went to him. She got 18 grand, and 16,000 in civil penalties were paid to HUD. So again, lots of cases like that. Just have to kind of watch out. Again, if you're managing property, that's what you're studying. You're looking out for that kind of stuff. All right, let's move along and get started with what's our next one, number 5, right? This one's entitled Distressed Property and Working with Professionals Outside of Brokerage. The state of Illinois really does want you to have an understanding of who the other experts are that you should be willing and able to work with, and know where your expertise ends and that of other people begins, including with lawyers, which we talked about a little bit last time. So Brenda is a wannabe investor, right? And she knows exactly where to go to learn everything. She goes to take a brokerage course at a community college, and like every one of you, she passes. Awesome. Well, life is just great, right? She's on the verge of untold wealth. But she doesn't actually get licensed, right? She contacts Bob, the local broker, whose tagline is, "Fixer-uppers are my specialty." I don't know what that means, but you better really know a lot about remodeling houses. Because she's kind of interested, so she asked Bob to see a bunch of his listings, is what it says, but we don't really know if they're his or her or wherever they come from. And then the saga kind of goes on from there. So she ends up with a mess of a place, right? She's in over her head, I think. Is that what ends up happening here? She trusts Bob. She's going to hire an inspector. Bob hands her a copy of the contractor's report and says, "Why waste money on an inspection? You got this already. You'll get an appraisal soon." Appraiser's going to inspect the house, which is, hopefully you know, is categorically wrong. Appraisers don't inspect. Brenda gets really busy, which tends to happen when you do things like go back to school or try and remodel your first house. Question number 1, what liability does Bob, fixer-uppers are my specialty, the broker, have in this whole scenario, if any? What's Bob done here so far? I mean, he's Has he been honest and forthright and straightforward? Has he lied, committed fraud, misrepresentation? What do you think? At a minimum, I suspect he's committed, misrepresentation of the property condition. I don't know how you, as a broker, I don't know how you ever utter the words, "don't get an inspection."
Where was the, disclosure form required?
Yeah, let's see what we know about this property.
It's never like really mentioned in
So, I guess we're assuming that these cases are all in Illinois, and I don't know if every state has a disclosure form. If it's bank-owned, there would be no disclosure form. It says several distressed properties, some of which are bank-owned. I don't know if we know about this one.
This one was bank owned.
This
Okay.
one was bank.
Well, if that's the case,
This
then
one,
there's not gonna be a
disclosure.
disclosure. They're just exempt. Which in and of itself is problematic. I looked at a property not too long ago. What was the deal? Oh, I know. Was looking at it with an investor and went into it for the second time. I'd shown it to an individual, too much work. Went back when the lender decided to drop the price way below market and set a fixed date, bids are due by date X. All bids are due, Friday, May 8th or whatever. So that shows up in the MLS all of a sudden. So instead of the house, the asking price being $275, let's say they ask $225, knowing it's gotta sell for somewhere in between there, but they just, bank's sitting on this house for a year and a half. Good area, decent house, just got some bad conditions. Walk into it to look at it for this investor, by myself, but on the investor's behalf. And there's noise running everywhere and air moving in the house, and I thought, good God, what's all that air moving from? And I hear fans running. I said, oh, the fan must be on. And sure enough, the fan, the heater furnace fan, its zone, is set on. So I turned it off, and I'm still hearing fans running. What the heck? So I turned that back on, and I go downstairs, and there's a half a dozen fans drying out the basement. All the carpet's been pulled out. Before, there had been a little strip. Drywall's been torn open. This house seriously took on a lot of water while it was listed. And I thought, okay, now I'm annoyed, because the law says if you're a bank and you take something back in foreclosure, you're exempt. But that stinking bank right now knows exactly how that water came in and how much it came in and what the problem is, and they still aren't disclosing anything. And my investor was interested in making an offer, but it was clear that the investor was gonna make an offer way below what any home occupant buyers would make. And so I sat down with them, went through the numbers. I said, look, let's say, for example, that you're gonna offer, they were asking $225. Let's say that you think $225 is the right price for a home buyer. You're gonna offer $175 because you gotta have profit, you gotta have carrying costs, and you want a contingency. Home buyer doesn't care. They're gonna go, oh, we'll buy it, we'll fix it up over time, and we'll make some money or whatever. So I figured that alone was a $50,000 spread between an investor and between somebody who was gonna move in, because from the first floor and second floor, the house was very livable. Could use some modernizing and some updating. The outside looked like it was attacked by woodpeckers or something. The siding needed to be replaced on 3 sides. Vinyl siding with tears in it all over the place. Never seen anything like it. Anyway, maybe it was hail damage or something, but it was still livable, except at the basement I thought, what the heck is that? And there was a retention pond back behind the place. So I thought, okay, does this happen every so often? Does this house flood regularly? There's an English basement on the back side of it. I didn't really know. Anyway, so I contacted the broker because I thought, I'll bet you I can force this broker to disclose that, because the lender is exempt, but the broker is not. That was my opinion. But she already told me that they already were getting a number of offers coming in. I thought, oh, forget it. So the investor just said, forget it, and they didn't bother. But I thought, what do you do with that? So if I'm a listing broker and my bank doesn't have to disclose, but I now know that it took water in the middle of the listing, don't I have to have a disclosure form? Because that's what my guy wanted to know. My guys wanted to know. Where did that water come from? Because if it's a one-time thing and the sump pump went bad, fine, $500 and then new carpet and stuff. But if it's something else, what's it gonna cost? 5, 8, 10 grand? They wanted to know. In fact, I think that's what they did when they ran their numbers. they included like $8,000 to fix the water problem, not knowing if it was a $500 problem, but whatever. That's how he came up with the number that was 20% less than where I thought it would go for. And I can just tell you that after the fact, she said to me that, well, we got multiple offers and we were way above the final asking price of what I would have when I gave 2.25. So even the 50 grand spread wasn't enough. And I don't think anybody knew where that water came from. I think they all just assumed it was a bad sump pump. So even if you have to have a disclosure, or don't have to have a disclosure, I think you still get, somebody ought to be able to tell you in some cases. Because if that problem happens after you've taken it back, I think there should have been a disclosure form. I don't know. It would have been, if I had excess money, I would have litigated it just for the sake of figuring out how a court would have ruled. It's certainly bad law, I think, that somebody who's holding a property who's exempt because of the way they obtained it doesn't have to disclose a problem that happened after they took it back. That just doesn't seem right to me. So you can read the Disclosure Act and see what that says. So anyway, bank owned, so we have no disclosure. Now back to the question, what liability does Bob have? Following on that, let's just start with that. Well, let's just look at what has he done, what has he said. Bank has assured me this house is in good structural condition. I have a letter here from a contractor assuring us that this house only needs minor cosmetic repairs. A do-it-yourselfer such as you shouldn't have any trouble fixing it up and flipping it quickly. What's the risk that Bob is taking? Assuming that everything here is legitimate and up, and that the contractor really believes this is the case, what risk is Bob taking by telling her, don't hire an inspector, just rely on the contractor's report? What's he assuming? If the contractor is right, then what if he isn't? This is why we want agents to recommend multiple home inspectors, multiple contractors, multiple lenders, multiple attorneys, and then let the clients choose. So here's a letter from a contractor. I got 2 other names. You can contact them if you want. Or you can hire a home inspector. Or you can go out on your own and just rely on this letter. Whatever you do, though, Ms. Beyer, it's your call. Right? I mean, if you just did it that way, and then she says, it's okay, I'll trust them, I'm in, whose problem does it become? Hers, right? And because now she's making the choice to rely on this contractor. Again, I spent a lot of years in construction, and as an agent, you gotta be careful. Lawsuits follow the money, and you'll get the biggest chunk of change at the closing, so be careful of that. How about Bob sponsoring broker? Just like George to Ted, how about Bob's broker here? I don't know if this will get hit as hard as the discrimination situation would. But still, potential liability is there.
Would that fall under errors and omissions, maybe?
Maybe there, in that case.
Wasn't it like careless misrepresentation?
Well, it's negligent misrepresentation if it's done out of ignorance or accidentally, or just poor practices. It's fraud if he trumped up the letter, or the contractor said, sure, buddy, I can give you a letter, but this place is gonna fall down next week. Then it's a case of fraud. Again, fraud is not covered under professional liability, though they may have to prove that that's the case, to get out from underneath the coverage. Negligent misrepresentation, I think, might be covered by E&O.
When you talk about recommending a contractor to look at a house to see if it's okay,
Yeah,
under Illinois law, if 2 or more parts of the house are inspected, it has to be a licensed inspector. Are you under any liability if you don't tell them to get a home inspection instead of just getting a contractor?
I would give them their choice and then tell them accordingly. So, I mean, if she's like, well, I don't have $400, that's where you run into this. You should be saying is you really should get an inspection. Well, I don't have $400 it's gonna cost. Well, here's an option, you know, you can get a contractor to come in and walk through the house with you and get their opinion. Or, you know, if you think it's a structural issue, you might be able to get a structural engineer to come in and look at it, but they're gonna charge you maybe as much as an inspector. It really makes sense to pull like the, you know, the licensed engineer thing. The other problem with contractors in Illinois is that they're not licensed. I mean, you know, well, they're licensed and bonded. No, that means they're licensed to the city for a $25 fee. It means they're registered. We do not license general contractors in Illinois. We license heating contractors, plumbing contractors, electricians, roofers, a handful of others, but the general contractors aren't licensed at all, which is one of the reasons why you can't just say, yeah, we'll have a contractor look at it, because there's no vetting of contractors in that regard. So, yeah, you might potentially, I'm just thinking in this particular case where he was saying just rely on this one. If you're gonna do that, give her 3 names, and, you know, then you're more likely to get, and be there with them as they walk through it and look at stuff. Because I think, you know, a good home inspector a lot of times will come from the trades, you know, will have been a carpenter, will have been an electrician or something, and they're just used to looking at things. You know, they're just used to looking at them and go, this isn't built right, or this isn't in the right kind of condition. I would tear this out, you know, redo it. So, I mean, I think that's part of what you get there. So if you have a good contractor who would say, sure, we're gonna gut this thing, take it down to the studs and, you know, add bracing or shoring or whatever, you could get the same kind of result, but home inspection is the way to go. That's, you know, would be the best. And I, you know, if you don't make the recommendations, you're taking on all the liability. It's just that simple. Should Brenda report Bob and his broker to the state licensing agency? Seems like all our questions all of a sudden are about turning people in. What do you think? You get out of this class, you don't go to the licensing test, you go and you find a house you really want to fix up. The broker, who maybe is the listing broker or maybe who's just your buyer's agent, shows you a place, talks you out of an inspection, tells you to take, you know, his buddy, the contractor's report for face value. You get into the thing, it's a mess, it's gonna wipe out your savings, it's gonna causing you havoc at work. Are you gonna file a complaint, or are you just gonna suck it up and deal with it?
You know, in a case like this where she had been through real estate classes in the past, and they went before, you know, the licensing board, would they take that into consideration, that maybe she was a little bit, you know, she should have been a little wiser?
Good question. What does anybody else think? Does taking this coursework and passing it elevate your status in the eyes of a court or a regulatory agency?
I don't think so. We're not licensed. We're technically not professionals.
So
Yeah,
once,
you know.
so what happens is once you go and pass the state exam and take your license to a, you know, your form to a broker, and they sign off and you sign off, that's the instant at which you become a professional and you're held to a higher standard.
But wouldn't she have some degree of, you know, I mean, she wasn't completely blind to what was going on.
Don't disagree, but it's still gonna be a professional versus a consumer. She wins, he loses, hands down. Simple case to me. If you're his defense attorney, you would absolutely trot out that argument. I agree completely. But I think you also counsel your client, Bob, buddy, we're gonna lose this one, but here's what I'm gonna do for you in the meantime. I'll stall by saying she had the greatest real estate teacher ever, she learned all the same stuff you did, no reason why she shouldn't have been able to look out for herself. All you did was act as a conduit to the MLS, and she knew it. That's what you would argue, and I think you would lose, but you would run up some nice legal
I still
fees.
think she was an idiot.
Yeah. Unfortunately, these kinds of things happen. I've had very smart and capable people get into, you know, house remodeling or, you know, multi-units or whatever, and I'll counsel them. I say, okay, just do one at a time. Do your first one, get it completely done under your belt, see how that goes, then do the next one. They'll be 2 months into a 6-month deal, or 6 weeks into a 4-month, you know, remodel or whatever, you know, including putting it on the market and testing the market and seeing how it actually goes. And they get all excited because this first one seems like it's going okay, and they jump right into the next one. Happens all the time. And they're still just considered consumers. Did we even get to question number 2, or we were still on number 1? I guess we were still on number 1. Let's take a break. Let's come back at 5 after, and we'll see about finishing this one up and getting into the next one.